Thank you, and welcome to another episode of Hawaii's Three-Digit Project, sponsored by the HSBA, the Living Legend Lawyers. We have with us today three of our top plaintiffs' attorneys, three of the best of all time in state history. On my immediate left, we have Gerald Sekiya, who is bar number 740. Next to him, Rick Freed, bar number 764. And next to him, on his left, David Fairbanks, bar number 735. Thank you for joining us, gentlemen.
Thank you.
Thank you.
I'd like to start with you, Rick. I would like to ask you, how is it that you ended up in Hawaii? What was the process in terms of education? How did you end up here? And how did you end up doing what you do? How did you end up being one of the top trial attorneys in our state's history?
It was sort of an accident, my getting here. I'd gotten drafted. I'd roomed with Barry Goldwater's son. Barry was a general in the Air Guard. I gotten drafted during Vietnam and finished my training as a navigator because it was shorter than pilot school. Had a choice of going back to Arizona in the summer, where it was 110 every day, or flying out of Hickam for my few months of guard duty. So I did that. My father had gone to the Sorbonne with a fellow that had a function. I met Alan Kay, and I worked for the largest firm in Phoenix and was probably going to go there and work. And he said, if you aren't totally committed, come talk to us. That was what was then Pratt Moore Bortson Case. And they offered me $800 a month versus $600 for the big firm in Phoenix. So that was a no-brainer.
Wow.
So I thought I'd try it for a year. And that was 1967.
67, you've been here ever since?
Ever since.
And so what year did you take the bar exam then?
68, that's when they had that year residency requirement.
Okay, so were you clerking for a year before to qualify?
No, I was working at the
You were
firm.
working,
Yeah.
okay.
As
And
I
then,
tell everybody, for at least 5 years, you're pretty worthless, so didn't miss a step by having a year to sit out.
okay, so you were working, studying, took the bar after a year of residency.
Exactly.
Okay, and so you started with the name of the firm again?
It was Pratt Moore Bortson Case,
Okay, and it became,
variety of things.
okay, all right. And
But when we left, it was still Pratt Moore Bortson Case.
Okay, and when you say we left, who left?
Jerry, myself, Paul Cronin, and Alan Haley.
Okay. And what was your idea? What was your dream at the time you left?
Well, Paul sort of initiated it, and the plan was to do a plaintiff's practice. We were the ones doing the litigation at that firm, and we were very nervous leaving. Fortunately, we had a few big cases early on, which got us over the hump, and we've grown from the 4 of us to 17 now.
When you first took on your first, well, let me ask you this: when you were working at the firm that you'd left, what kind of work were you doing? You said you were litigating, but were you doing plaintiff's work, defense? You know, insurance companies were hiring you?
Actually, insurance company work. In fact, we had a major trial, Jerry and I did, against Frank Padgett and Jim Kruger. It was our last defense case. We were defending Aloha Airlines when they had that miserable 1% rule for contrib. And that's how we escaped in that case. They found the plaintiff 1% at fault.
So when you first started, you talked about getting over the hump. What was the hump you had to get over? You had to take on a case, you had to finance it. Is that what you're talking about?
Exactly.
Okay.
And, just running the office, we were purely contingent, as we have been for 40 plus years. I can't remember if we've ever sent a bill. I know I haven't. And you have pretty significant expenses. Relatively, they were less then. But we luckily had a few pretty good results earlier. We could have been scrambling.
Okay. So when you do it that way, are you all in? I mean, do you look to Jerry? Do you look to Paul? Do you look to Haley and you say, hey, how much you have left on your credit card? We need to keep this case going. Is that how it works?
Well, almost. But basically, what's a little different about our firm, I think, is we all work on, there's no silos. We all work on everyone's cases as needed. I mean, certain of us have sort of focused on, like I do, seemingly a little more aviation and medical malpractice. Jerry does a variety of other things, plus keeps the place running.
Okay. So when did you start the Cronin, Freed, Sekiya, Fairbanks? When did that start?
Jerry, you want to jump in?
Yeah,
Thank
that
you.
was,
Thanks, Jerry.
Greg, that was actually in 1973. And the decision to leave the firm we were at, as Rick says, we were kind of the trial department. Cronin headed the trial department at Pratt Moore Wardson case. And Rick was a major part of that. I was, Alan Haley was. There were a few others, but we were basically the core trial department of that law firm. And we did more insurance defense work. We did a lot of commercial litigation, a lot of trial work actually, and very, very few. I can remember only one plaintiff's case that Paul and I tried against Wally Fujiyama and Wilfred Watanabe right before we left. But what happened was Paul, one day, Rick, I know, was very happy where he was at. I was. We had very good relationships with the lawyers there, Danny Case, Alan Kay, Al Stack, Paul Lynch. Then one day, Paul walks into my office and he says, and he's one of the seniors by then. Actually, Rick, by that time, the end of 1972, Paul's name was in the firm name actually. But Rick and I had just been made partners by the end of '72, and it was at an accelerated pace, which we were very grateful for, of course. So things were great. Paul walks in and says, "I'm leaving the firm." I was in shock. And he says, "I'm leaving the firm. I'm going to start a plaintiff's practice, and I want you, Rick, and Alan Haley to join me if you will." And as I say, I'm sure Rick was. I was in shock. I didn't know what to do. We had a lot of discussions about what the decision would be to go or not go. Eventually, I think with my situation, what convinced me with Paul was him pointing out I had always wanted to be in a courtroom, and I didn't care what area or field it was in. He said it's going to be purely a plaintiff's practice, and he said that it would have to be exclusive. And so we had to make a decision about that. And he pointed out that if I really loved trial work, would I be happy indefinitely representing the haves against the have-nots, as opposed to have-nots wanting or needing against the haves? And that really was a telling factor.
Did you have to, did you have a young family at the time, Jerry?
Two
Did you
kids.
you had to talk to your wife about your decision?
Yes.
Get her okay and blessing for that?
That's right, because she put me through law school. We got married right before we went away to San Francisco, and she worked through law school and put me through, so all these decisions had to be made with her involved, and that's correct.
All right. David, when do you join this group?
I'm the Johnny-come-lately. Joined in 1985 after having spent 17 years at Goodsill doing defense work, trial work.
Wow. And it's been a while now that you've been with
Yeah, it's 30 years.
Yes, yeah, it doesn't
But
seem
it doesn't seem it.
No, it doesn't. And you were doing trial work at
Correct.
Goodsill before, and
Defense
insurance
work.
defense work.
Insurance defense work, and I also did a lot of public utilities.
Okay, so you made that same transition as these two gentlemen did.
Yes, but their firm was already established, so I didn't have a lot of the risks that they took.
Okay, so you weren't the one that had to say, well, I've got $5,000 left on this credit card, but I've never tapped this one. We can use that.
Well, not for the firm's purposes, but maybe my own
Yeah.
personal.
Okay.
Yeah,
Well,
interestingly, the thing is, when Cronin says, he says, we're going to have to do things my way. And my way is very simple. Exclusively plaintiffs' personal injury work. Secondly, try cases and no settlements. You got to try them because we were nobodies. And in order to develop a reputation and get cases, in his opinion, we have to try these cases. And he wanted to diversify the firm. So one of the things he was against was hiring any more Howleys, but Dave was an exception, as was John Thomas. But we went after Wayne Kikina.
Yes.
Very, very soon, within 2 years after we started. Wayne was a target of ours. He was with the Lipcoman firm.
Also doing defense work.
And so we ended up picking him up as an associate along with Evelyn Lance, who was one of the first, she was the first lady graduate from Columbia Law School, I believe.
Wow.
And she joined us in '75 along with Wayne too. Wow. And we always had our eye on Dave and Thomas, for that matter.
Right. Well, you know, Jerry, you brought up the first woman graduate of Columbia, and in prior episodes, some of our guests have talked about the difference in the racial makeup of firms in Honolulu at different times. Did you ever face any of the, I don't know if it was outright discrimination or reluctance in terms of being hired because you're Asian American? Did you ever experience anything like that?
You know, I went to Hastings for 3 years. As I say, I was married. My wife put me through law school. I was very fortunate to get a job with the Federal District Court in San Francisco, Northern District of California. I clerked there for 2 years. In that 5-year period, I was away from Hawaii, knew very little about the recent past. I was fortunate that the people from Pratt Moore Watson case came and interviewed me. I also was fortunate to be able to sit down with Wally Fujiyama because he had a connection with Hastings, as well as I think his son was about to go there or was going there. So he would stop by, and he filled me in on the Hawaii scene, which included his take on the history of racial discrimination in Hawaii. And I ended up going with a law firm that Rick was at, where there were 15 lawyers, all of them were Howley. There was no non-Howley.
You were the first one?
I was the first one. And ironically, I ended up coincidentally with an office the only office in a cubbyhole in the law firm's office that faced the reception area. And that's the only office that the people sitting in the reception could see into the office. So the guys, my friends, when they come by, they say, "Hey, Sekiya, you're not talking Japanese, and everybody put you where everybody can see you." I said, no. It wasn't a problem, but I mean, it existed.
Okay.
And the fact of the matter is, there were, as Dave points out, even the Goodsill firm ended up hiring an Asian very late.
1968, when I joined the firm, the first Asian was hired was Ron Long, whom I had known as a kid. We used to play sports together.
First one.
And Pratt Moore Watson case was the classic Kamaina Howley firm. Everybody there was very beautiful. I mean, they were great people. They were at the tennis ground, Pacific Club for lunch ground. Wasn't quite my cup of tea, but I got along, I think.
Yes.
You know?
Yeah.
And I didn't have to participate in that way.
You didn't have to
Things
play
went fine.
paddle
I didn't
tennis
have to
with
play
them?
paddle tennis or tennis.
Okay.
I didn't even know how, but
Yeah, oh, that's
so,
great.
anyway.
Well, thank you. Okay, well, we're going to take a break right now, gentlemen. We'll get right back to it. Thank you.
Hi, I'm Ethan Allen. I host Likeable Science on ThinkTech Hawaii, and I do this because I care about science literacy in Hawaii. I want to spread the understanding that science is a vital and interesting part of everyone's life. I want to make sure the broadest possible spectrum of people understand the beauty and the value of science and realize that science plays out each and every day of their lives. I want you to understand that science is fun. So we bring onto this show each week guests who are scientists, from astronomers to zoologists, and we talk about what they do and how they do it. But most importantly, we talk about why you should care about their work, why you should see that their work has value and impact on your life. So I hope you'll join us Fridays, 1 p.m. here on ThinkTech Hawaii. You can watch us via live stream. You can watch us recorded on Olelo, and you can see us each week. We hope you'll join us.
Yeah. Okay. Well, thank you. Welcome back. We have three of our preeminent trial attorneys, plaintiff personal injury attorneys. Our topic today is building a plaintiff's personal injury firm, and these three gentlemen have certainly done that and more, and we're very fortunate to have them. Rick, can you tell us about any particular case that stands out in your mind as being, you know, particularly significant to you personally?
There's some that were very interesting. I ended up, well, the firm did, but I ended up trying the case with Alan Haley, where a Sidewinder missile made by Raytheon during an air show off the Philippines went awry and hit a helicopter, which was the next thing in the show, killed all 6 aboard because of a mal-design. And I still remember in picking the jury, there was a guy on there from McDonnell Douglas, and he seemed to be tracking. But, you know, this is against Raytheon, another engineer. I thought this would be history. So I finally used a peremptory challenge. As he walked by, he said, "I hope you get those bastards." So,
Rats.
Yeah.
Yeah.
And what's cute, a little off colors, all 6 guys were married, none had kids. And this was a 2-month trial. And the gals would refer to themselves as Rick's chicks. And so we got along very well.
Yeah,
So after all this with the jury, we came in the next day and the judge called us in. He had his protractor out. We were outside a Marine League, so he threw the jury out and we tried it to the judge, which ended up actually quite well.
Oh,
But we've had some very interesting ones, couple that have had some long-standing ramifications. Remember the United Door that blew off?
Sure,
years ago?
747.
I was representing 17 of the 18 flight attendants. We ended up most of the summer in San Francisco trying those cases.
Right. Was that row like 13H and GNH?
What's really interesting...
The reason I remember that, I think it was on that very flight a week before and sat in that seat.
Oh my gosh.
Yeah, yeah.
Well, what happened is
That's why
a
it sticks out
whole
in my
row
mind.
of business class got sucked into the engine.
Right.
And the business class was about half full. So people were moving around all before they took off. So they moved in and out of the spot. But we had good results in that case. And what happened as a result, and I still see United flight attendants, and some of them stay in touch with me that I represented, that the incident is still their training film for the training of the flight attendants.
So some real good has come out of that.
Yeah. Another one similarly was the young child whose father had come back from Iraq and had seen his son born. It was in vitro. They really wanted this child. And the pediatrician delivering after the child was born said, "Well, he's fine, but we'll give him a little oxygen to pink him up." And unfortunately, it was not a birthing room usually, and they had a tank of carbon dioxide in there. And they gave the kid the whole tank of carbon dioxide. And you could see it moments of birth. The kid was pushing his hands away from this thing, and they kept saying, "Gee, we'll give him some more and more." And after the full tank went in, 30-some minutes later, they realized the mistake. And so as a result of that, the entire military now delivers their anesthesia in a different fashion. No more of these individual tanks.
Another good consequence of a very tragic situation.
Terrible deal.
David, tell us about some cases or relationships that you have built as a result of some of the work you've done, and then tell us about this Hump case that we're referring to earlier that you know something about historically with the firm.
Well, a couple of them. One of the aviation cases that I got involved in was the Aloha Airlines case when the skin of the aircraft peeled back. And we handled all of the plaintiffs in that case, got them resolved. But it also changed the way Aloha Airlines did their inspections. So that's one of the reasons why I like doing plaintiff's work, is that you're really helping someone who needs help, and you are changing things. Things get better. A couple of other cases that I was involved in, one was the Benlate case, where the firm represented 11 orchid growers on Oahu against DuPont for a contaminated fungicide. And that was an incredible case. It was like a war. But like all the cases that we try, we do it on a collaborative team basis. Everybody, whatever resource is necessary, we put on it.
You throw at it.
We throw at it.
Yeah. How do you, what's the process that you undergo in selecting what clients or what cases to take? Your screening process, if you will.
Well, as you know, we're a contingency firm case. If we don't win or recover, we don't get paid. We also advance all the costs. So we have to do as good an investigation to begin with to see whether we're going to take a case or we find ourselves in trouble. So we do due diligence. And when it comes right down to determining whether we're going to take a case or not, some of the more senior people, the old people here, get together and we argue about what the investigation shows. Should we take this case or not? So that it is a firm decision.
Okay. And then how do you arrive at a value? How do you evaluate?
Virtually the same way. We do a workup. We hand out and talk to partners about it, and we get together and we argue about it to see if we can't come to some sort of range, a low range and a high range. And that's basically how we evaluate cases.
Okay. And then when do you get the client involved? After you've come up with this range? When do you get the client involved in that decision?
Well, obviously, we get the client involved when we're trying to make a settlement proposal and when we get into negotiations, because obviously, ultimately, it's the choice of the client,
right,
whether to accept it or go to trial.
Okay, David, could you fill us in on this case, this early case handled by the firm that you're aware of?
I'm aware of it. I think Jerry was the one actually involved in it, and had it not come out the way it did, I wouldn't be here.
Well, yeah, what he means is that, within about 6 months of us opening the law office, Rick and I had this trial with Dick Stifel at Goodsell and Bob Rothwell at the city and county.
Were you working on the other side of that case?
I was not on that specific case, but Dick Stifel did all of the Hawaiian Electric poll cases.
Okay. And we represented a teenage girl who was the passenger in the front passenger seat of a car driven by her boyfriend, who kind of drifted off the main drag and ran into a pole. And we sued Hawaiian Electric for inappropriate placement of the pole, and the city and county for inadequate signage and markings. And Rick and I went for about 3 weeks. There were a bunch of experts who are very expensive, as we all know, not only on the medicals because she was in a coma, but on liability.
Right.
And ironically, halfway through the trial, I remember Rick going, Sekiya, we got at least one vote. There's this one lady on that jury who I've got this rapport with, And
what
so
that
anyway, we ended up with a hung jury, 6-6, and that lady was the leader of the pack against us. And we ended up with a mistrial and had to start another trial. The judge made us start within 3 weeks after the end of the first one. So we go back to back with 3-week trials. Thank goodness we won the second one.
But I have to interject. Jerry was just driving. It was a Kailua pole placement on the apex of the curve. So he was just over there kind of looking at the scene, because in the first case, one of their defenses was what the plaintiff's expert has said we can't do. It's not possible as an electrical arrangement. He found exactly what they said they couldn't do on another setup over in Kailua, and that made an enormous difference in the second trial.
Yeah, that helps.
And he has an engineering background, so that made a big difference.
So in any event, we prevailed on the second case. What Dave's point is if we lost on both cases, the firm may not have survived beyond that point. And it was shortly after that, within a couple of years, that we had Ono versus Applegate, which is a dram shop case on Maui. And so Wayne and I had to fly to Maui to try that case.
And those are expensive cases on those
very,
neighbor islands.
very expensive.
Right.
Yes. There was Bill Fleming defending against us with Peter Char. John Thomas was on the other side representing the driver on a limited insurance policy, and there was no Act 300, so we couldn't settle him out. He did a terrific job against us, and so we hired him after that.
Oh, okay.
Yeah.
Okay.
Another
Did you
early-
survive that case?
We did survive that.
Okay.
Yeah,
And
they
we went
went
up to
well.
the Supreme Court, actually.
Okay, yes, it did, yes, it did.
Yeah, and prevailed on Hawaii recognition of a draft shop claim.
Another early case was involving a Hughes helicopter, which we asserted had a defect in the tail rotor and crashed, rendering the police helicopter pilot paraplegic. And we had sued Hughes Corp, and we were trying to get discovery, and they were running us into the ground, had no interest in anything. As it turns out, by now, Howard Hughes had become a recluse and was living in the desert inn. Somehow, the sheriff we got to serve him got service. And Sam King, who was the federal judge hearing the case, ordered him out here. Well, he was not about to come out here. And so as soon as that happened, the case settled for what it was worth. That was another early case that could have...
Luck of the draw there. luck
That
of the
was
service.
very unusual.
Yeah, that is. That's a fantastic story.
If I might interject as a
Yes.
Johnny-come-lately, one of the things that is unique about our firm is that most of the senior people came from defense firms. So they have done insurance litigation, know how insurance companies operate. So it gives a unique perspective and balance to the work that we do as plaintiffs' lawyers.
Right, some insight on how to present
Correct.
settlement demand or
Correct.
that kind of thing. Reserve, some
Right.
knowledge about setting of reserves.
Right.
Okay. So David, what, since you've joined the firm as this newbie of 30 years, what have you been, you're part of this team, but what has been your focus, if you have one?
Variety of things. I don't do as much medical negligence as Rick does. I have done some. I've done some aviation, not as much as Rick does. Do a lot of products, been helping with the toxic tort kinds of cases and the general injury cases, product liability.
Okay, all right. Tell us about your educational background. We know about Hastings, we know about the University of Arizona and Barry Goldwater, son.
Well, I'm a product of Hawaii's public school system. I went to Punahou 13 years. And then I went away to school to learn the ways of the white man at Stanford. Then I went in the Marine Corps, and then I went back to law school at Santa Clara.
Marine Corps. How long were you in the Marine Corps?
3 years, ended up in Vietnam for a little while. When the Marines shipped out of Kaneohe, I went with them.
Wow. Wow. What was that experience like, David?
Well, I hit a lot. But it's a life-changing experience, no question about it.
Yeah, I'll bet. So were you drafted or did you enlist?
No, I was single. Right at that point, I was not going to be a lawyer like my old man. I was going to be a school teacher, and I had actually taught modern European history at Punahou. And then I went in the Marine Corps. So what else am I going to do?
Okay.
I wasn't fit to do anything else.
Okay. Well, what did your parents have to say about that?
They weren't happy I was in Vietnam. They were happy that, I think they were at least not happy, but they were satisfied that I served the country.
Okay.
They were not happy because both my brother and I were in Vietnam at the same time, and that wasn't supposed to happen.
Right. Yeah, that must have kept them up at night.
Right.
Yeah. Well, Jerry, let's get back to you. I'd like to ask you if you can tell from your experience of beginning as an associate with this firm that you started with, right up till today. Let's talk about technology first. What do you think has there been any transformation of the practice of law from the plaintiff side as a result of technology, or not? Is it the same game now as it was then?
I think it's basically the same game that it's always been. It certainly has changed the way in which things get done tremendously, but as far as evaluating cases, representing clients, evaluating liability and damages and all, and preparing for trial, it basically has the same core of an infrastructure that has just been improved upon by high tech.
Okay. Thank you. We're going to go to another break.
Aloha, I'm Hunter Hevelin, host of Sustainable Hawaii here at ThinkTech Hawaii. You can tune in every week on Thursday at 2 p.m. to see interviews with sustainability professionals from around the state and even further abroad, learning about activities with water management, food security, waste management, and a whole host of other fascinating opportunities to get engaged with making a greener island. So if you're interested in making the transition from consuming individuals to communities of producers, check us out every Thursday.
This is Alice Lee Hagan, host of ThinkTech Hawaii Business Education Spotlight. My show here at ThinkTech Hawaii is every Thursday from 3 to 4 in the afternoon. I bring in interesting guests from Hawaii, the mainland, and hopefully international guests in the future. Do join us on Thursday from 3 to 4 p.m. ThinkTech Hawaii Business Education Spotlight. Aloha.
Hi, I'm your host on ThinkTech Asia, Bill Sharp. I look forward to you joining us each Monday between 4 and 5 o'clock when we film right here in our studio in downtown Honolulu. The show, ThinkTech Asia, focuses on contemporary events in Asia. And by Asia, we mean anything from Hawaii, south to Australia and New Zealand, west to Pakistan, and as far north as the Russian Far East. Clearly, this is one of the most economically dynamic centers of the world, and we bring you up to date on what's going on in a whole host of countries in this very vital region. We look forward to seeing you. Aloha.
Welcome back to our Living Legend Lawyers 3D project, HSBA, here at ThinkTech Hawaii. We have, our topic today is building a plaintiff's personal injury law firm, and we have three of the top lawyers in that field. We're so fortunate to have these three-digit members with us today. Rick, could you answer the question about the, maybe in the courtroom, since you spend a lot of time there, how has the technology changed between when you tried that first case with Jerry and today in terms of maybe handling your experts or your evidence?
Well, it has, but in essence, you're still doing the same thing. In federal court, it's very techy. You can do depots right from the courtroom. You can do witnesses from the courtroom. But in essence, it's still important, I think, in front of the jury to have it live. Not too much jazzy stuff. I think the millennials are a little different, but we just finished a 3-week trial in late November with basically a zero offer on a med-mal case. And, it was the team more than me, but we got 7 figures more than we asked for. So it wasn't tried particularly differently, just hard work, getting the witnesses prepped. And we have 3 medical people in the office, and so out of every maybe 25 calls we get, we might only investigate 1 or 2 at most, just because something goes wrong. And as Jerry was saying, we eat the cost. This was not unusual expenses, but this trial in November, our costs were about $150,000. So, I mean, that's something you need to think about a little bit before you jump in there. But I kind of think that all of us, fortunately, are in the position that we probably financially could retire. But I really enjoy the way clients, like this last trial, we've been good friends. We had sort of a party. The client, this was, his last chance. Mm-hmm. And it really makes you feel good when you can help somebody. And in fact, often when we turn down cases, they're very unhappy with us because this is their last chance. But we tell them, this is how we make our living, and we don't want to put you through all this and then have a bad result. And we have credibility when we bring a case. We vetted it. We've done a lot of homework. And, I think we'd all rather, maybe I'd rather be hitting a tennis ball than harassing some doctor that shouldn't be. I can completely understand. And so it's very rewarding when the clients are mostly appreciative. And I'm always in on Saturdays when I'm here and call clients, and they're very appreciative. But very rarely, they're so happy you're doing their case. There isn't much of this where they're really calling any more than we would be talking to them anyway. Certainly you have a difficult client once in a while. In fact, last year, we turned away a very solid case because the client was so difficult, and somebody will run with it and make a nice fee, but life's too short for that.
Yeah.
And that's why our firm has grown, because in the bigger cases we handle, we can't get overwhelmed, or don't. If we were a 3 or 4 man firm, we have enough people to support us to fight back.
Okay. And David, you know, it occurs to me, and Rick just addressed it, that this practice that you're in could be kind of a high maintenance practice in terms of these people who's placed their lives in your hands to get the result that they need to continue. How do you service them? What is there a formula? Is there a calendar? Is there a docket? How do you do it?
Well, there's no formula, but the amount of contact is certainly tailored to the client and the client's needs and how needy they may be for information. I think we meet with them from time to time, and we set out what the steps are and what's going to happen, approximately how long it's going to take. But if they have any questions at all in the interim, to call one of us or one of the paralegals that's on the case, so that there is this constant or frequent contact with them, and that we are personally available to answer their questions.
So you make that clear right up front.
Absolutely.
My phone, I'm a phone call away.
And multiple times, at various times throughout the handling of the case.
You tell them there's no dumb questions here?
Correct.
Okay.
Correct. And it's something you need to explain it, and explain it in terms that they can understand, and to be patient.
Okay. I'd like to address this next question to the entire panel. We have lawyers now, young lawyers now, with bar numbers in the 10,000, soon to be 11,000. And I'm wondering if there's, based on your experience, your trial work and so forth, interaction with judges and authority, is there any advice, start with you, David, that you would give to these young lawyers who are going to be watching this show?
Sure. First, I'd like to say that although we have 3-digit attorney numbers, that does not equate with 3-digit ages, regardless of what we look like. But I would say, first of all, as a lawyer, you have one asset, and that's your reputation. And that is something that you need to build and keep and preserve. Once your reputation is tarnished or lost, it is almost impossible to get it back. And that's really what you have to offer as an attorney. Secondly, this is a small town, it's a small state. And even though the bar is growing, it is still small. People know each other. And you need to be civil, you need to act with candor, you need to act with honesty with other lawyers on other cases all the time, because you're not always going to have the upper hand with the case that you have and the facts that you have. So you need to do that. The third thing I would say is, remember, it is not your case. It is the client's case. You do what is best for the client. And sometimes that is at odds with what you personally would like to do or your personal agenda. Just remember that. Not your case, it's the client's.
So are you sort of saying don't let your ego get in the way at times when necessary?
Absolutely.
You might want to react a certain way based on what's happened to you, but that may not advance your client's cause.
Correct.
Okay. Is there a fourth thing?
I leave that to them.
Let's go to Rick. Rick, why don't you?
Well, one of the differences, I think, when Jerry and I were starting, we were probably doing 6 jury trials a year. It was much less complex. You'd whip in. I remember with Alan Hawkins, Joe Schneider was defending. We did a whole trial in one day. I mean, it's mind-boggling. The trial would have taken a week now. And there was, I think, less discovery now. It's really quite different in that respect.
More time-consuming, more costly.
Both. And we're all in this group of defense and plaintiffs lawyers called American Board of Trial Advocates, and I forget how many trials it is. But Jerry has less gray hair than anybody in it because nobody's getting to court now. And there's this plus and minus, because if you can resolve it in mediation, that's obviously better for your client, less stressful. But it's getting very, very hard to get the trial experience. It's extremely difficult. The judges don't like to see you very much over there when they order you out to mediation and arbitration. And yet, I think to resolve a case, the defense needs to know that you're willing to go to trial if you have to, and we still do that.
Has that diminished your marketability at all, Rick? I mean, because you're a good gunfighter and you can't shoot people in the street anymore, does that mean nobody will hire you? I mean, how does...
I would hope that would be the opposite, that they know that we're more than happy to mediate, but if we can't get it done, we'll go ahead and try it, because if the defense senses you're not going to try the case no matter what, boy, it's going to get tough to resolve it where it should be resolved.
Right. Jerry, how about you? Any
Well,
words of advice?
the only thing I would add to what's been said is I've noticed that newer lawyers, less and less, are being respectful of the court and the judges, and I would urge that maintaining respectfulness of the judges and common courtesy with their staff, as well as with colleagues, of course, but more so with the judges. I think some word needs to be said about maintaining that respect.
Respect for that black robe, for that
Yes.
position. But do you, and any of the three of you can respond to this, any stories from interactions with judges in the past that you've found particularly funny or serious, or something that you've learned from?
Well, the day I started at Pratt Moore Woodson case, I walk into the office and Danny Case says, Sekiya, you claim you want to go to court a lot. We got a calendar call. I had no idea what that was. That was a trial setting. So he gives me a file and he said, all you do is you go down there and the judge is going to give you a trial date. And so he gives me directions. The very first day I started, I go down, it's Judge Fukushima. And the case I had was, and I looked through it very quickly, and it was a condemnation case. And so when our case is called, I go in there, and the judge looks at me, and he looks at who was on the other side. Vern Tashima was representing the agency condemning. And he gives a date, and then he says, okay, Mr. Sekiya, will you waive jury? Apparently it was common practice to waive a jury, and of course there was no way I could waive a jury. You know, and I said, Judge, I'm sorry, I can't do that. He said, why not? I said, I have no authority. Mr. Sekiya, he was yelling at the top of his lungs. I couldn't believe what was happening. I was in shock. And you know, he said to me, the next time you come to my courtroom unprepared or unauthorized fully to act on behalf of your client, you're gonna be held in contempt. The next time I showed up, I was ready for everything. He gives me a trial date, and I look at Cronin's calendar. I had Cronin's calendar, and it says trial. And he says, what court? Of course, it doesn't say which court it is, whether it's federal or state. I said, Judge, I don't know. He went ballistic. He went truly ballistic. I couldn't believe what was happening. And I said, this is too much, you know. But I hung in there, and he had the probate calendar. I showed up at probate case. He starts off by saying, Mr. Sekiya, did you read the file? Judge, I read every page in his file. He pauses, kind of smiles, and he never said anything, but I could just see him giving me that message, you did well, you know? And so in the end, I mean, these judges probably mean well, and us lawyers need to be respectful.
Yeah. Well, thank you very much, all three of you. But we've come to the end of our show. Wish we could go for another couple hours. I really do. But I really appreciate you guys taking the time out of your busy schedules. And I know you're very busy to come down and talk to us. Thank you.
Thank you.
Thank you. Good job. Thanks.